everyone, and welcome back to the channel with some unfortunate news that I did not see coming. As you saw in the title and maybe the short that I posted yesterday, the Supreme Court has sided with the ATF over the frame and receiver rule. Now, I'll admit it, after the Bruin ruling, I thought that this one would be a slam dunk, especially with the Fifth Circuit being on our side. Turns out I was wrong. But as I have told you guys, I am not a lawyer, and I am definitely, obviously, not a Supreme Court justice. So let's break it down. The Supreme Court ruled 7-2 in favor of the ATF, with the only dissents coming from, of course, based Clarence Thomas and Justice Alito. The case, previously called Garland v. Vanderstock, now Bondi v. Vanderstock, involved the Biden-era ATF rule that suddenly decided that parts kits, 80% lowers, etc. were full firearms subject to background checks and serial numbers because they could become full working firearms, despite these items being fully legal beforehand and a part of a long American tradition of building your own firearms. Writing for the court, Associate Justice Neil Gorsuch said that the Gun Control Act of 1968 permits the ATF to regulate these items. But what's interesting is that Gorsuch says the rule passed muster not from a Second Amendment standpoint, as that wasn't the argument made in the case, but under the Administrative Procedures Act. But before I explain that argument to the best of my non-lawyer ability, this video is brought to you by the actual attorneys at the Attorneys on Retainer program. If you ever find yourself in a self-defense incident, you do not want to have to face it alone. The folks in the Attorneys on Retainer are actual lawyers from the Attorneys for Freedom law firm, whose entire job it is to give you legal advice and represent you if you use your gun in self-defense. They are not an insurance company, so their only requirements are that the incident happened after you signed up and that you reasonably acted within good faith. They're not there to protect their own butts with fine print or liability, and you are not sent through an insurance adjuster before a lawyer even looks at your case, which is unfortunately what often happens with insurance companies. They cover everything from felonies to misdemeanors, appeals, and even bail bonds. So switch over from your existing self-defense coverage by heading on over to my link down in the description and use code LIBERTYDOLL to get $50 off your individual sign-up. Now, here is part of Gorsuch's argument. Before ATF could enforce its rule, gun manufacturers and others filed what they described as a facial challenge under the Administrative Procedure Act, arguing that the GCA cannot be read to reach weapons parts, kits, or unfinished frames or receivers. The district court agreed and vacated the rule. The Fifth Circuit affirmed, holding that 921A3A categorically does not reach weapon parts kits regardless of completeness or ease of assembly, and that 921A3B reaches only finished frames and receivers. Section 478.11's provisions addressing weapons parts kits are not facially invalid under 921A3A. That subsection contains two requirements. A weapon must be present, and that weapon must be able to expel a projectile by the action of an explosive designed to do so or susceptible of ready conversion to operate that way. Some weapon parts kits meet that description. Consider, for instance, Polymer 80's Buy, Build, Shoot kit, which contains all necessary components to build a semi-auto pistol and can be assembled in about 20 minutes using common tools. That kit qualifies as a weapon because 1. Artifact nouns like weapon often describe unfinished objects when their intended function is clear, as with a disassembled rifle. 2. The statute treats starter guns as weapons, though they require conversion work. And 3. The statutory text contemplates that some things short of fully operable firearms qualify as weapons. The kit also satisfies the statute's second requirement, as it requires no more time, expertise, or specialized tools to complete than a starter gun, which the statute treats as readily convertible into a functioning firearm. While other kits may be so incomplete or cumbersome to assemble that they cannot fairly be described as weapons capable of ready conversion, the facial challenge fails because kits like Polymer 80's clearly qualify. As for treating unfinished frames and receivers as fully functional firearms, despite not being part of a kit, he had this to say. Section 478.12c's treatment of partially complete frames and receivers is also not facially invalid under 921A3B. Like weapon, the artifact noun's frame and receiver may describe not yet complete objects. The statute uses these terms to encompass some unfinished items elsewhere, as in 923I's serialization requirements for incomplete weapons, silencers, and destructive devices. ATF has for decades interpreted the statute to reach some unfinished frames and receivers, and even the plaintiffs concede they have no quarrel with ATF's prior practice of regulating those products. Accordingly, the statute authorizes ATF to regulate at least some incomplete frames or receivers that take minutes of work with common tools to complete. While other products may be so far from finished that they cannot fairly be described as frames or receivers, the facial challenge fails because the statute plainly reaches some partially complete items. Now, you might notice that these are some pretty concerning arguments, because what's to stop gun controllers from saying, well, semi-autos should be banned or at least more regulated because they could become full auto with minutes of work? Sure, that might be a bit hyperbolic, but it's the same logic and was brought up in the case. The good thing out of here is that SCOTUS actually addresses that one. The plaintiff's fears are misplaced. The government represents that AR-15 receivers do not qualify as the receiver of a machine gun, nor the government emphasizes has ATF ever suggested otherwise. Much the same can be said of our reasoning today. As we have stressed, a statute's text and context are critical to determining whether and to what extent Congress used an artifact noun to reach unfinished objects. And without doubt, the NFA and GCA are different statutes passed at different times to address different problems using different language. Our analysis of the GCA thus does not begin to suggest that ATF possesses authority to regulate AR-15 receivers as machine guns under the NFA. Now, that opinion is all well and good, all fluffy unicorns and rainbows, but the court also put out Bruin, and we've seen state after state and law after law ignoring Bruin and the Second Amendment. We've seen the same thing with the Heller decision. It also hasn't stopped judges in lower courts from ruling in favor of these gun control laws rather than Bruin or Heller. So, to me, saying that this decision won't then apply to future gun control efforts doesn't really hold water. Especially when we take into account Sotomayor's point that a long-standing right and tradition is merely evasion of the law. For more than half a century, firearms dealers, manufacturers, and importers have complied with the Gun Control Act's requirements. They have marked their products with serial numbers, kept records of firearm sales, and conducted background checks for prospective buyers. These requirements are not new to the industry, and covered entities know they must maintain familiarity with the statute and accompanying regulations to run their businesses. In fact, the Act requires such entities to obtain federal licenses before selling, manufacturing, or importing any firearms in the first place. What is new is that some manufacturers have sought to circumvent the Act's requirements by selling easy-to-assemble firearm kits and frames, which they claim fall outside the statute's scope. ATF's rule simply confirms what was already clear. The Gun Control Act does not tolerate such evasion. In his dissent, Clarence Thomas took issue with several points of the majority opinion. The text, context, and structure of 921A3 leave little doubt that weapons parts kits are not firearms, and that the unfinished contents of these kits are neither frames or receivers. But even if it were reasonable to treat artifact nouns differently, the government would, at most, demonstrate statutory ambiguity. And when a statute with criminal applications is ambiguous, the rule of lenity applies. Nothing in the Gun Control Act suggests that the terms frame and receiver also include the materials that one could use to create them, or that parts including neither a frame or a receiver could constitute a weapon. There are, however, many reasons to conclude the opposite. Even the government appears to have found these competing interpretations persuasive just a few years ago. See brief for ATF 14, 36 through 39, endorsing the position it now rejects. Now it says the opposite. The law hasn't changed, only an agency's interpretation of it. Congress could have authorized ATF to regulate any part of a firearm or any object readily convertible into one, but it did not. I would adhere to the words Congress enacted. Employing its novel artifact noun methodology, the majority charts a different course that invites unforeseeable consequences and offers no limiting principle. I respectfully dissent. And respectfully, Justice Thomas, thank you. Now, all this being said, Trump could, hypothetically, overrule this decision and strike the rule down. It would be in line with his order to Bondi and his Make America Safe Again agenda, where he claims that he will uphold the Second Amendment. But the question remains, will he? And will he and Bondi meddle in a Supreme Court decision? I'll admit I am not too confident here, but we'll see. For now, unfortunately, the frame and receiver rule will stay on the books. Well, ladies and gentlemen, that is it for this sad sack unfortunate video. You guys know the drill for all of the algorithm things. Please do them. And as always, thanks for tuning in. Stay safe out there and happy shooting.